ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know the lane for what you saying, yo. I'm sitting with my 9 million with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While I'm in the club, I be while in the studio. You don't wanna vibe, me, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. I'm a nigga that'll slap you with the toolie, yo. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga, shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. See this what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. See this what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. See this what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. See this what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. See this what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. See this what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Yo, 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 yo. Hey, guys. It's the late night shift. Lord have mercy. I'm going to wind up breaking night, guys. I think I'm only going to get a couple of hours of sleep. Lord. So what's up, everybody? I dropped the link for those who would like to come in and help me read. That would be totally awesome. We got about 103 pages. Let's see if we can make this as quickly as possible so I can at least get 4 hours of sleep.
Yo, yo.
Oh boy, what's up, Papi?
What's going on?
What's up, bro? You sound great. You're loud. You're clear.
Man.
And so we got Auntie Ann's paperwork, bro. Auntie Ann said, you know what? I'm going to drop the ball on y'all in the middle of the night just because she likes to do surprises. We love you, Auntie Ann.
All
right. So I guess we can each go to, I'll read one subject and then you'll read the next subject.
Okay.
All right. Let's do it like that. Let's go. Okay. So this is the memorandum, decision, and order by Judge Donnelly, guys. The United States District Judge. The defendant, an international music star, was charged with using his fame and organization to lure young people into abusive sexual relationships. A racketeering enterprise that the government alleged spanned about 25 years. Over the course of a 6-week trial, the government presented the testimony of 45 witnesses and introduced hundreds of exhibits, including written, videotaped, and audiotaped evidence of the abuse to which the defendant, enabled by his employees and associates, subjected his victims. On September 27th of 2021, a jury convicted the defendant for that conduct. Before the court are the defendant's motions pursuant to federal rules of criminal procedure 29 and 33 for a judgment of acquittal or in the alternative for a new trial. I see you, whoever's back there, give me a second. And then it says the document numbers, and then it says, in seeking this relief, the defendant attacks almost every aspect of his trial: the sufficiency of the evidence, the credibility of the witnesses, his trial lawyers' competence, and the court's evidentiary rulings. The government opposes for the reasons explained below. I deny the defendant's motions in their entirety. Auntie Ann said, no, nigga, no. What's up, team? What's up, guys? Auntie Ann denied it automatically.
What up? What up?
What up?
Say what's up to the people, guys.
What up? What up? What up? What up?
Y'all? What's good?
Oh, you brought me in. Hey.
What up?
All
dude?
right. All right, you guys are all good. So look, we're each gonna pick a section, all right? So Larry, this is your spot now.
Indictment. The defendant was charged on a third superseding indictment with racketeering in violation of 18 U.S.C. 1962, transportation of Jane for the purposes of illegal sexual activity and violate. Somebody cut your volume off.
Yeah, everybody mute. I'm about to mute too.
Sexual activity in violation of 18 U.S.C. 2421. Count 2, coercion of Jane for the purpose of illegal sexual activity in violation of 18 U.S.C. 2422. Count 3, coercion of a minor. Coercion of Jane as a minor for the purpose of illegal sexual activity in violation of 18 U.S.C. 2422. Count 4, transportation of Jane as a minor for the purposes of illegal sexual activity in violation of U.S.C. 2423A. Count 5, transportation of Faith for the purpose of illegal sexual activity in violation of 18 U.S.C. 2421. Count 6, coercion of Faith for the purposes of illegal sexual activity in violation of 18 U.S.C. 2422. Count 7, transportation of Faith for the purpose of illegal sexual activity in violation of 18 U.S.C. 2421. Count 8, and the coercion of Faith for the purpose of illegal sexual activity in violation of 18 U.S.C. 2422. Count 9.
Okay, Nooni or Atmos, we're each picking a section. So, Atmos or Nooni, which one want to go first?
I can go. Hold on.
Okay, go ahead, Nooni.
Okay, so what part?
Curcio.
Curcio hearing, Mama.
Okay. Let me make it bigger. Curcio hearing on June 14th and 24th, 2021, the government advised the court that Nicole Blank Becker, one of the 4 attorneys who represented the defendant at trial, had potential conflicts of interest in representing the defendant. The government asserted that in the summer of 2019, Ms. Blank Becker may have entered into attorney-client relationship with someone who was represented by Gloria Rodriguez in Chicago and was ultimately testified as a government witness. The court appointed independent counsel, Lana Hamadi, to advise the defendant. The court conducted a Curcio hearing on June 17th, and July 15th, 2021. Ms. Blank Becker and Ms. Rodriguez had written submissions and both answered a series of questions posed by the court. Keep going. After considering the submissions and the attorney representations, the court concluded that Ms. Blank Becker had potential conflicts in representing the defendant, but that the conflicts were waivable. In particular, the court found that Ms. Blank Becker had substantial contacts with potential witnesses, including Jane, and may have developed a relationship or trust with them, even though she was never formally retained as their lawyer. Let's see. Due to Ms. Blank Becker confidentially Okay, my bad.
You want me to take it on there?
Well, I don't know. It moved, so hold on. Where was I at?
Due to Ms. Blank.
At the lawyer?
Yeah.
Retained. Okay. Due to Ms. Blank Becker's confidentiality confidentiality of obligations to them, and given the nature and extent of those communications and the content of them, she would have a conflict if there were to be cross-examination either one of them. The court also determined that Ms. Blankbecker's communications with both women, knowing that they were represented by another attorney, could raise ethical concerns that two created potential conflict, because a person would be motivated to defend himself or herself from the accusation in a way that might keep the lawyer from asking certain questions or calling certain witnesses. Addressing the defendant, the court explained in detail the risks of being represented by a lawyer who had potential conflicts that the court identified. The court also explained that if the court determined that the defendant's waiver was knowingly and voluntarily, the defendant would not be able to cite Ms. Blankbecker's conflict as a reason to overturn a conviction. The defendant responded that he understood the risks, including his waiver of the right to use conflict as a basis for a challenge to a conviction, and at the court's request explained his understanding for the potential conflicts. Ms. Harmati, Curcial counsel, confirmed that she had sufficient time to meet with the defendant, that she explained the conflicts to him, that he understood them, and that he was capable of making an informed waiver of his right to conflict-free counsel. The defendant explained that he wanted to continue with Ms. Blankbecker as one of his lawyers and waive the conflicts based on the record. The court accepted the defendant's knowing and intelligent waiver.
Pretrial motions. In February and March of 2020, the defendant moved to dismiss count 1 of the indictment and the counts of the indictment incorporating New York Public Health Law Section 2307, ECF NOS 4142. In moving to dismiss the count 1, the defendant claimed that the indictment did not allege a legally cognizable enterprise within the meaning of RICO, ECF 41 at 5 and 10. In the second motion, the defendant moved to strike the charges that cite Section 2307 on the theory that the law is unconstitutionally broad and vague, ECF 42. The court denied both motions in a written decision on May 22nd, 2020, ECF number 69. On the morning that the oral portion of the jury selection was set to begin, the defendant moved to dismiss the indictment on other grounds, ECF NOS 159 to 169. The court denied that motion also, issuing a subsequent written decision, ECF number 252. Before the final pretrial conference in August 3rd of 2021, both parties filed motions in limine, ECF numbers 121, 133, 135, 136, and 137. As relevant here, the government sought to admit certain uncharged conduct, ECF number 133. The defendant responded, ECF number 146. At the August 3rd, 2021 pretrial conference and prior to opening statements on August 18th of 2021, the court ruled on most of the parties' requests except for those on which the court reserved decision pending hearing the trial evidence. On November 4th of 2021, the court issued a written opinion explaining the rationale for its ruling.
Grown boy, can you take over this section for a moment? Grown boy, you there? Atmos, continue reading, puppy, please.
The court in jury selection. The court employed the following system for jury selection. At the court's direction, the parties submitted a joint proposed jury questionnaire, ECF number 54. Subsequently, both the government and the defense submitted the request for additions and changes to the questionnaire. The court reviewed the submissions and modified the questionnaire accordingly. ECF number 115. It says the end result was a 28-page questionnaire with 108 questions. Approximately 575 prospective jurors completed the questionnaire. Next, the parties reviewed the completed questionnaires and agreed that 251 jurors should be stricken for cause. ECF number 152 and 157. The court directed the remaining prospective jurors, whom neither party had challenged, to appear for an in-person voir dire. In addition, the court directed the parties to submit any questions that they had to the court to put to the prospective jurors. The parties filed those questions before the oral voir dire. On August 9th and August 10th of 2021, the prospective jurors appeared for questioning. The court addressed them as a group and explained the rules that they must follow and the principles. It says, and the principles of law that applied, including that the defendant was presumed to be innocent and that the government had the burden of proving the defendant's guilt beyond a reasonable doubt. The court questioned the prospective jurors' individuality and asked the written questions the parties submitted. The court also asked the parties whether they had additional questions for jurors and to put those questions to the jurors. Following the in-person voir dire, the parties exercised their challenges both peremptory and for cause. At the end of the jury selection,
Preemptory.
Yeah, okay. You got it. Which took place over the course of 3 days. The court impaneled 12 jurors and 6 alternate jurors.
Trial. The evidence at trial established the following facts. From the early 1900s until its arrest in 2019, the defendant, a famous recording artist and professional singer and performer, was the head of an organization comprised of employees and associates, including managers, engineers, accountants, personal assistants, and so-called runners who promoted the defendant's music and brand, but also catered to his personal needs and demands. For nearly 25 years, the defendant used his fame and his enterprise to lure young victims, girls, boys, young women, and men, into abusive sexual relationships, often promising to advance their musical careers. The defendant exerted control over his victims by limiting their access to family and friends, requiring them to engage in degrading sexual acts with him and multiple partners while he recorded them, forcing them to write and record false and degrading things about themselves or their families for the defendant to use as insurance, amongst other things. He also exacted punishments for violation of his rules. He spanked them, beat them, forced them to have sex with him, and recorded them during forced sexual encounters and performing other humiliating acts. His underlings enabled him by recruiting victims, transporting them, and enforcing the defendant's rules. The defendant lived in various residences in Chicago from the early 1900s until his arrest. They cite 9th Street, George Street, Olympia Fields, Trump Towers. He recorded music at CRC Recording Company in the 1990s, 865 North Larrabee Street, formerly known as Chicago Tracks, from 2003 to 2004, and the basement of his Olympia Fields residence beginning in 2004. The Larrabee Street and Olympia Fields studios were also called the Chocolate Factory. The defendant had many employees who worked for him in various capacities at different times, seeing to his professional and personal needs. The employees and associates included Demetrius Smith, the defendant's personal assistant and tour manager, Barry Hankins, another manager, Darryl McDavid, an accounting manager, Donnelly Lyle, a music director, Tom Arnold, a studio manager, Diana Copeland, the defendant's personal assistant, and then the executive assistant. The defendant also hired runners, including Nicholas Williams, Anthony DeVaro, Jermaine Maxey, nicknamed Bubba, was the defendant's close friend and member of his entourage. Cynthia Opafont Candy handled security. Top Gun was one of his defendant's drivers. The defendant's numerous personal assistants included Suzette Mayweather, her sister Alizette Mayweather, Diana Copeland, Bruce Kelly, George Kelly, Milton Brown, Cheryl Mack, and Van Pullen. These people and the defendant's other employees helped the defendant with all aspects of his life. For example, Arnold looked after the building, made sure there were runners available, provided cash and supplies, and helped engineers with documentation. He was responsible for stocking the tour buses and coordinated travel and accommodation. The runners answered the phones, took messages in the studio, transported guests, and ran errands, among other tasks. Copeland handled household responsibilities and made sure the defendant attended meetings on time. The defendant's employees were charged with contacting young women and girls for him, including those that he selected at concerts or saw at other locations. For example, members of the defendant's staff routinely handed out the defendant's telephone number to young women and girls in the audience at his concerts and invited them backstage to after parties. In addition, these employees would look for women and girls at local malls and other places and would give them the defendant's contact information. When the defendant wanted a young girl or young woman or girl referred to at the trial as his girlfriends or female guests to travel to meet him, the assistants arranged their flights and hotels. The employees were also charged with escorting these guests when they were out in public to shopping malls, nail salons, and to the defendant's basketball games. The runners drove the defendant guests to and from the Larrabee studio and the Olympia Fields residence and ordered food for young women and girls. In addition, the employees made sure that the defendant had his backpack, which contained his iPads and other devices that he used to record his sexual encounters and his guests. The defendant relied on his employees to enforce his various rules and to report any transgressions. For example, if a young woman or girl needed to use the bathroom or wanted to leave the defendant's home or studio, she was required to ask an employee, who then had to get the defendant's permission. If the guest wanted something to eat or drink, she had to ask an employee. The defendant required his underlings to report any guest who left the room without permission. When the defendant punished young women or girls for breaking his rules, including, for example, by forcing them to stay in a room on a tour bus, sometimes for days, the defendant's assistants were required to monitor them. If the defendant believed that his employees had insufficiently watchful or had permitted one of the women to break his mood, he confronted them and often punishing them, including by docking their pay. The defendant's herpes diagnosis. Dr. Chris McGrath, the defendant's primary physician from 1994 to 2019, treated the defendant for herpes beginning after June 5, 2000 and before March 19, 2007. Dr. McGrath advised the defendant to inform his sexual partners that he had herpes and to use a condom during sex, prompting the defendant to acknowledge that he should use a condom when he had sex. Dr. McGrath prescribed Valtrex for the defendant, which his underlings often picked up from the pharmacy. The charged crimes and the victims. Angela met the defendant in 1991 when she was 14 or 15 years old through her friend Tiffany. Angela wanted to be a singer and dancer, and Tiffany, who was also in high school and an aspiring singer, Tiffany told Angela about the defendant and brought her to his apartment in Chicago along with two other girls who were also in high school. The defendants and member of his entourage, Bruce Kelly, Demetrius Smith, and Larry Hood, were in the apartment when the girls arrived. Time out. Didn't it say that these niggas is going to be testifying in his Chicago trial?
Yes, they are. Bruce Kelly said that he will be testifying.
Oh, God. And he was there when the threesome, when he bought the girl.
When they were in the apartment together in the next room.
Okay.
This is going to be interesting. I love this. And Larry, you're reading like no other, bro. What happened to Amos? Where he went?
Man, Amos probably went to sleep.
He left us. I didn't even hear. Okay. Go ahead. You'll continue, and then I guess I'll go after this. I'll take the next subject.
Okay. The girls followed the defendants into another room one by one. There were already 3 girls in the room when Angela walked in. One girl was removing her clothes, another was standing there, and the third girl was taking off her shirt. The defendant told Angela to climb on top of him and to straddle ride him. Angela was a little startled, but she did as the defendant asked. She asked if the defendant had protection. He did not, so she got a condom, put it on him, and they had sexual intercourse in front of the 3 girls. The defendant had intercourse with at least one other girl in the room and engaged in sexual contact with all of them. When Angela left the room, Demetrius Smith, Bruce Kelly, and Larry Hood were still in the apartment. For the next few years, Angela saw the defendant with Tiffany and a different assortment of young ladies on a regular basis. At some point in 1991, the defendant told her to choose between going to school and a singing career. She stopped going to school, and she and Tiffany, another girl, formed a group called Second Chapter. From the time she was 15 until she was 17. Oh, man, I know who this is. Okay. From the time she was 15 until she was 17, Angela
Yes,
had
that's our
sexual
sister.
intercourse with the defendant at his apartment at his recording studio in Chicago, and while they were on the road. She did not want to have sex with him, but the defendant told her and other girls they had to pay their dues. In 1992, go ahead. You gonna pick up there, or you want me to keep going?
Yeah, I'll pick up from here. So yeah, we all know this is JoJo. Aaliyah Count 2 Racketeering Act 1. I can't. In 1992, the defendant and Demetrius Smith met Aaliyah at Houghton, Barry Hankerson's niece in Detroit, Michigan, on Aaliyah's 12th birthday. The defendant introduced her as the next up and coming artist to Angela and the other girls in the group. The defendant told Aaliyah that the three girls would be her friends and her background vocalists and dancers. Angela saw Aaliyah regularly in Chicago while Aaliyah worked on her first album, Age Ain't Nothing But a Number, which the defendant wrote and produced. Demetrius Smith was concerned that the defendant was messing with or seducing Aaliyah. In 1992 or 1993, Aaliyah joined the defendant on tour. During a stop in Washington, D.C., Angela saw the defendant performing oral sex on Aaliyah in the tour bus. In the middle of a 1994 tour, the defendant told Smith, "Aaliyah's in trouble, man. We need to get home." There were still other shows on the tour, but Smith made travel arrangements and they flew to Chicago after the show. During the flight, the defendant cried and told Smith that Aaliyah believed she was pregnant. But yet R. Kelly said he never had sex with Aaliyah. Get the fuck.
Facts.
What? And that Daryl McDavid said, this is why the judge, Auntie Anne, is going to look at him like the way Larry Nassar's judge looked at him and look at this paperwork and be like, this is a piece of crap. This shit your lawyer wrote for you and all this shit is a crap. You're a crap. And you're going to jail forever.
Well, yeah. Well, they asked me. They just asked me to
just for Aaliyah alone. All right. So during the flight, the defendant cried and told Smith that Aaliyah believed she was pregnant, and that Daryl McDavid said he had to marry Aaliyah to avoid going to jail. When Smith said that Aaliyah was too young, the defendant asked whose side he was on. The defendant, Smith, McDavid, and Tyree Jameson met Aaliyah in a hotel room. The defendant and the other men talked about the marriage, including the fact that they would have to get false identification for Aaliyah, who was only 15 years old and too young to get a marriage license. Smith said that he could pay someone at the local welfare office to create a fake identification card for Aaliyah. Smith got $500 from McDavid, and the group drove to the welfare office. Smith went inside and offered $500 to an employee who agreed to create the false identification card. The defendant waited in the car while Aaliyah went inside the office. The employee photographed her, gave her the card, and she returned to the car. The defendant knew someone at a local FedEx where they got a fake work identification card for her. So not only did they got two IDs for Aaliyah. They did not just get one. They got two IDs for the price of one. How about that? Smith, McDavid, the defendant, and Aaliyah went to the Maywood City Hotel, where the defendant and Aaliyah applied for a marriage license. The defendant, June, and Smith asked Keith Williams to find the minister for the wedding. Williams recommended Nathan Edmond. Edmond officiated the ceremony. which was at most 10 minutes long, in a hotel room, and about an hour later, Smith, the defendant, and Jameson flew back to the concert venue. Aaliyah stayed behind. Shortly after the wedding, the marriage was annulled. Stephanie, count 1, Racketeering Act 2. Stephanie was born on October 16, 1981, and grew up in Chicago. She graduated from the Chicago Academy for the Arts in 1999. She met the defendant when she was 16 years old. And how old was it that Ms. Bonjean said she was? 17? Oh, because here it says 16, because that's what I thought it said from the get-go, 16. She better get it together over there. She met the defendant when she was 16 years old at the Rock and Roll McDonald's in downtown Chicago. A man approached her and asked for her age. She responded that she was 16. He asked if she knew R. Kelly, and she said she did. He gestured to the defendant, who was seated at a booth, and said the defendant wanted her to call him. He handed her a note with the phone number. Stephanie threw the note away because she did not intend to call the defendant. She saw the defendant about a year later in the summer of 1999 when she was 17 years old. So she asked if he would listen to her friend, an aspiring singer. Okay, so she re-met him again when she was 17 in the summer. The defendant agreed to meet Stephanie's friend and perhaps help her with her career, but wanted to get to know Stephanie and asked her if she would cuddle with him. Stephanie replied that she would, and the defendant gave her his number. Stephanie went to defendant's recording studio a week or two later. An employee took her to a second-floor waiting room and told her to wait for the defendant. The defendant arrived a few hours later. He told her that he wanted her to call him daddy, and they had sexual intercourse. Stephanie continued to see the defendant for the next 6 months, mostly at his studio, and they had sexual intercourse every time she saw him. Occasionally, one of the defendant's employees picked her up and dropped her off at the studio. The defendant was one of two ways. He was either very nice and charming, jovial, or he was very controlling and intimidating. He'd raise his voice at me, and he could put the fear of God in me very quickly. Sex with the defendant was humiliating. He told her what sounds to make and often ejaculated on her face. The defendant also positioned Stephanie's body in very specific ways and sometimes would leave her completely naked with her butt in the air for hours.
Wow.
If she was not in the same position when the defendant returned, he got very angry and yelled at her. He did not allow her to speak to other men. Following one of his basketball games, he directed her to perform oral sex on him, even though there were two other people in the car. He told her to make noises because he wanted the people in the car to know. While Stephanie was 17 years old, the defendant videotaped their sexual encounters. On one occasion, he gave her instructions about what she should do, including when to undress. He placed his video camera in front of Stephanie, who was completely naked, had sex with her from behind, and put a dildo in her mouth. Following a trip to Florida, during which the defendant used a small handheld camera to record her performing oral sex on him, she decided to end the relationship because she felt used and humiliated and degraded. She also wanted him to destroy the sex tapes, so she saw him one or two more times, but he did not destroy the tapes. And when she called and asked if she could get the videotapes or if they could destroy them together, he said it was possible if she came to the studio. So she realized that he did not intend to destroy the tapes, and she never spoke to him again. All right, Noonie, you want to go at Addie? Are you still there, Noonie?
Yes. Okay. Addie met the defendant at a Miami concert On September 2nd, 1994, when she was 17 years old, the defendant announced from the stage that women over 18 could go backstage. Addie did not go because she was only 17. Minutes later, however, two bouncers asked Addie and her friend if they wanted the defendant's autograph. The man did not ask the girl's age and led them to the defendant's dressing room. The defendant autographed Addie's program. When Addie said that she was an aspiring artist, the defendant wrote his hotel room number on her program and suggested that she come to his room for an audition. Addie also told the defendant that she was 17 years old. The defendant said something to his bouncers, who escorted everyone else out of the dressing room. They told Addie and her friend to stay. The defendant played a song from an upcoming movie and told the girls that he wanted to play a game to determine which girl was a better kisser. The defendant kissed Addie's friend and then kissed Addie. When she tried to pull away, the defendant held her wrist, pulled her shorts down, and then had unprotected sex with her from behind. Addie was in a complete shock, and her mind basically went blank. When the defendant finished, Addie pulled up her shorts, opened the door, which had been locked, and ran out of the room with her friend, Kate. Kate started a sexual relationship with the defendant in 2001 when she was 27. Before she had sex with him for the first time, Kate asked if he was okay and if he was going to use protection. The defendant said that he was not going to use protection. He did not tell her that he had herpes. Kate was not sexually active with anyone else at the time, subsequently contracted genital herpes. The defendant did not respond or ask any questions when she said, "I think you gave me something." In 2004, Kate retained a lawyer. The defendant paid her $200,000 to release her claims and to refrain from making public statements about her relationship with the defendant. Sonia, the jury heard testimony from Sonia, a 21-year-old intern at a local radio station who met the defendant at a shopping mall in West Valley City, Utah in August 2003 and wanted to interview him. He invited her to Chicago for the interview. When she arrived at the studio, she was detained in a room for days. When an employee brought her something to eat, she passed out only after a few bites. She awoke to find her underwear had been removed and that her vagina area and thighs were wet, and saw the defendant pulling up his pants. The jury found that Racketeering Acts 3 and 4, which charged the defendant with kidnapping and Mann Act violations, were not proven beyond a reasonable doubt. Nevertheless, the government maintains that the evidence also constituted evidence of the existence of the enterprise, that means and methods of the enterprise, and the defendant's pattern of racketeering. Alexis? Okay, you want to go? Go ahead.
Alexis met the defendant in Jacksonville, Florida on March 26, 2006, when the defendant was 15 years old. A man told Alexis and her friend that the defendant wanted to meet them backstage. The defendant gave Alexis his number, and they met the defendant the next day on a tour bus in a mall parking lot, where he made her sign a non-disclosure agreement. Alexis may have told the defendant she was only 15. His general response was, "There's nothing wrong with platonic friendship at the time, and if it turns into some overtime, then so be it." Alexis saw the defendant repeatedly for the next few years, including Jacksonville, Miami, and Chicago. She first had sex with the defendant when she was in her teens, but not before she was 18. The defendant did not use protection and did not tell her he had herpes. Lewis, my main man, Lewis. Lewis was born on February 1989. He met the defendant in 2006 when he was 18 years old, working at a McDonald's in Markham, Illinois. For everybody that don't know, that's south of the city. South Markham. That's where all the clubs at. The defendant also asked Lewis if he could hook it up for the defendant and Lewis manager. The defendant handed Lewis and his manager his phone number and told Lewis to call. Lewis gave the number to his mother. She called the defendant and said that Lewis was an aspiring rapper and a big fan of the defendant's music. Lewis and his parents attended a Christmas party at Olympia Fields. At one point, the defendant whispered to Lewis that it would be best if he came to see the defendant by himself. Lewis' mother called the defendant again by Lewis' interest in music, and the defendant invited Lewis to his studio. Lewis rapped for the defendant and another man. They told him he had potential, and the defendant invited him to come back the next day. Lewis returned and recorded a song. The defendant listened for only a few seconds, but said he did not like it. Lewis left the studio feeling discouraged. Shortly thereafter, the defendant invited Lewis back to the studio. He took Lewis into a garage and asked Lewis what was he willing to do for the music. As Lewis started to explain how hard he would work, the defendant interrupted and asked if Lewis had any fantasies. The defendant got onto his knees. Oh, whoa, okay.
Larry, you're gonna love this part.
Whoa, I ain't see this coming. The defendant got onto his knees, unzipped Lewis' pants, and performed oral sex on him. In the ensuing months, Lewis and the defendant had several sexual encounters, which the defendant recorded on a camcorder, tripod, or an iPad. The defendant asked Lewis to call him daddy and called Lewis his little brother. Daddy? Okay. The defendant also instructed Lewis to have sex with women, which the defendant recorded. On one occasion, the defendant took Lewis to the garage, and when the defendant snapped his fingers 3 times, a naked, very petite young lady crawled out from under a boxing ring. When the defendant ordered her to come here, she crawled
that
over.
Was Joy.
Yeah, she crawled. Wow. She crawled over to him and performed oral sex on him. The defendant told Lewis to pull down his pants and directed the young woman to do Lewis the same way she did him. She complied, and the defendant told her to say Lewis' name and tell him that she liked him. The defendant also met one of Lewis' friends, Alex, who was a year younger than Lewis. On one occasion, the defendant directed Lewis and Alex to kiss and touch each other. Neither wanted to do it, so the defendant told Alex, let's show him how it's supposed to be done. And Alex and the defendant had time out.
Yeah, you heard right, bro. You heard right, bro. Like I said, he was having kids have sex with kids and taping it.
Neither wanted to do it, so the defendant told Alex, let's show him how it's supposed to be done. And Alex and the defendant had sex. One of the defendant's girlfriend, Dominique, went to Lewis High School and was a year younger than Lewis. The defendant found out that Lewis was talking to Dominique on the phone. He directed her not to talk to Lewis and didn't want anything to do with Lewis after that. In 2019, Lewis met the defendant at the Trump Towers in Chicago. The defendant dictated a letter which Lewis wrote to the effect that some people wanted to pay Lewis to say he had a sexual relationship with the defendant. The defendant told Lewis that the letter was for their protection. Alex. As explained above, the defendant met Alex through Lewis. Alex had multiple sexual encounters with the defendant in the defendant's home studio and tour bus. The defendant called Alex's nephew and told Alex to call him daddy. The defendant also directed Alex to have sex with different women while the defendant recorded the encounter. Sometimes the defendant participated and other times he masturbated. The defendant was in charge during these encounters and gave instructions to Alex and whichever woman was involved, including to do it like you mean it. During these encounters, the women appeared zombie-ish. Geronda Pace, born on April 19, 1993, admired the defendant's music and was a member of his fan club. She met him in 2008 outside the Chicago courthouse when she was 14 years old. She spoke to him occasionally during the next 2 months. In May 2009, when she was 16 years old, the defendant's employee, Bubba, invited her to a party at the defendant's house in Olympia Fields, which she attended. The defendant said he remembered her from court. She said she was 19 and they exchanged numbers. The defendant invited her to his house a few days later and told her to bring a bathing suit. A runner named Anthony picked her up from the train station. Once at the house, Anthony walked Geronda to a room with a swimming pool and she put on her bathing suit. The defendant arrived and told her to take off her bathing suit and walk back and forth. After Geronda complied, the defendant walked her to another room and performed oral sex on her. Geronda felt uncomfortable, told him she was 16 years old, and showed him her state ID. The defendant responded that she should continued to tell everyone that she was 19 and to act 21, and then had sexual intercourse with her. The defendant did not use protection, did not tell her he had herpes. Geronda had a drink and felt ill, so the defendant took her to the mirror room to rest. The next morning, she texted the defendant that she was leaving. A runner bought her $50 and dropped her off at the train station. The defendant also suggested that she bring a friend to the house. She introduced him to Dominique, who was 17 at the time, and another member of the fan club. Geronda learned that Dominique was visiting the defendant's house, but she did not see her there because, according to the defendant's rules, they were not permitted to leave their rooms. One night, the police came to the house looking for Dominique. The defendant, using a speakerphone, told his lawyer that the police were at the house. Geronda continued to see the defendant over the next 6 months. They had sex each time she was there, and the defendant recorded their sexual activities with his Apple iPhone and a Canon camera on a tripod. Geronda contacted herpes while she was seeing the defendant. He arranged for her to see a doctor. The defendant required Geronda to follow his rules. For example, she had to wear baggy clothing and was not permitted to leave a room without the defendant's permission. If she needed to use the bathroom, she had to text him or call one of his employees. She had to call the defendant daddy and acknowledge him when he came into the room. On one occasion, the defendant called her and directed Geronda to come outside of his tour bus, which was parked next to his house. When she arrived, the defendant was there with a naked young woman named Juice, who the defendant said has been with him since she was 15 years old. He told Geronda that he was going to train her on how to please him sexually and then order her and Juice to perform oral sex on him. The defendant made Geronda sign a non-disclosure agreement. He also directed her to write a letter which she falsely said she stole $100,000 jewelry in cash, and her sister forced her to say that the defendant gave her herpes and she was the defendant's employee and that he had fired her. The defendant punished Geronda when she broke his rules. He slapped her when she disagreed with him. In January 2010, Geronda did not greet him appropriately because he was texting a friend. He slapped her and choked her until she passed out. He spit in her face and told her to put your head down in shame. The defendant ordered her to perform oral sex on him, ejaculated on her face. She used her t-shirt to wipe her face. Geronda hired a lawyer to bring a civil suit against the defendant. She gave the firm the t-shirt she used to wipe her face and her cell phone. The lawyer settled the case for $1.5 million. Geronda got that bag.
Let me go next.
Okay.
Anna, as we all know, you know who that is, right, bro?
No, I don't.
Haley. This is Haley. Haley Calhoun, bro.
What?
Yes, sir.
No, not Haley. Okay.
Yes, Haley. That's our girl, Haley. Anna went to one of the defendant's concerts in 2016 when she was 19 years old or 20 years old. Afterwards, Bubba told her that the defendant wanted to meet her. Anna met the defendant in his dressing room, and they exchanged contact information. Shortly thereafter, they began a sexual relationship. Anna lived in the defendant's Trump Towers apartment in Chicago and traveled with him in his Sprinter van to his concerts around the country. The defendant paid for Anna's travel and hotel, which his assistants arranged. The defendant became more controlling during the course of the relationship and required Anna to follow his rules. She had to call him daddy, could not talk to or look at other men, and had to get the defendant's permission to go anywhere, even to the bathroom or to get food. The defendant required her to wear baggy clothing and a baseball cap when she went out in public. He also controlled her use of social media and internet and monitored her conversations. The defendant administered punishments, which he frequently recorded when he believed that Anna broke a rule. He spanked her so hard that he left bruises and then demanded that Anna send him text messages that she enjoyed the beatings. On one occasion, he forced Anna, who was crying, to walk back and forth wearing only high heels and to repeat over and over that she was a slut and stupid while the defendant slapped her. The defendant recorded these punishments. The defendant ordered Anna to write letters, which he dictated, in which she made false and embarrassing statements about herself and her family. He kept these letters for protection in the event that down the line, something would happen, the defendant would not let Anna see her mother until the mother wrote a letter falsely admitting to a blackmail scheme against the defendant. In the event that Anna's mother were to come against him in any type of way. The defendant told Anna to give the letter to Copeland. The defendant also forced Anna to do embarrassing and dehumanizing things, which he recorded. For example, he ordered her to be sexual and seductive with bodily fluids, covering herself with urine and feces, while the defendant told her what to say. Also, at the defendant's direction, Anna had sex with him and others, including Jane, Dominique, Joy, and Alex, while the defendant recorded the encounters on his iPad. The defendant never used the condom. Now, Anna was tested for sexually transmitted diseases, but did not see the results because the doctors sent them directly to Copeland. So Anna's relationship with the defendant ended sometime in 2018. Noonie, you want to read Jane?
Yes. Jane, count
Mommy,
one racketeering.
do me a favor. If you can,
Yeah.
I don't know if you should maybe speak up a little louder or get closer to the microphone because you sound kind of low.
Okay, is this better?
I guess. Go ahead.
Or not really?
Yeah, you're good now. You sound a little bit
Okay.
closer. Yeah.
Okay. Jane, count 1, racketeering acts 8, 9, 10, and 11, counts 2, 3, 4, and 5. Jane was born on December 30th, 1997. She met the defendant at an Orlando concert in April 2015. When she was 17 years old, Jane, a high school junior, was active in varsity sports and in her school choir and hoped to be a professional singer. During the concert, a member of the defendant's entourage handed Jane a sheet of paper with the defendant's phone number. Jane texted with the defendant and spoke with him by video call. She told him she was a musician and that she was 18 years old. The defendant invited her to an audition at his hotel room. When she arrived, the defendant was in a Sprinter van. He asked her to sit on his lap and give him a kiss, which she did. They went to his hotel room, and the defendant told her he needed to ejaculate before Jane sang. Jane did not want to have intercourse with him, but at the defendant's direction, took off her clothes, and the defendant licked her butt. Meanwhile, Jane's parents were trying to find her, and the security officers arrived. Jane told them that she was 18 and handed them her identification, which she showed that she was only 17, but they left. The defendant continued the sexual contact, ejaculated, and then told Jane to sing. He praised her and said he wanted to see her again and teach her a few techniques. The defendant invited Jane to travel to Los Angeles, one of the next stops on his tour. His assistant, Cheryl Mack, made Jane's travel arrangements, and Jane flew to California. The defendant had sexual contact with her at a hotel. He told her about some of his rules, that she must wear loose, baggy clothing, call him daddy, and get his permission to leave the hotel room. Jane traveled to Stockton, California, where she and the defendant had sexual intercourse for the first time. The defendant did not use a condom and did not tell her he had genital herpes. Jane stayed with the defendant in Chicago during the summer of 2015. The defendant did not permit her to leave the room without calling him or an assistant first. If she had to use the bathroom and could not reach the defendant or one of his employees, she had to urinate in a cup. She and the defendant had sex almost every day, which the defendant frequently recorded using iPads that he kept in a backpack. Jane, still 17 years old, contracted genital herpes with pain so severe that she could not walk. Juice booked a doctor's appointment for Jane, When the doctor told her that she had herpes, Jane was devastated. She told the defendant, who was agitated, and told her she could have gotten it from anyone. Jane responded that she only been intimate with him. From that point on, Jane got herpes medication either from the defendant or his doctor. The defendant told her that everyone has it and that it's no big deal. Before she went back to Orlando for her senior year of high school, Jane told the defendant she was only 17. He slapped her face and walked away. He returned and told her that they would figure this out. Jane went back to Orlando, but she and the defendant convinced her parents to let her live in Chicago and do virtual online homeschooling. The defendant arranged for Juice's mother to act as Jane's legal guardian. The defendant assistant booked Jane's travel to Chicago, for which the defendant paid. Afterward, Jane joined the defendant on his tour, traveling on his tour bus from city to city. At one point during the tour, Jane thought she was pregnant and asked the defendant what he would do. He said that he would want her to get an abortion because he wanted her to keep her body tight, and that if she was any other age, it wouldn't make a difference. As Jane learned, the defendant had so-called live-in girlfriends, Juice, V, Dominique, and Joy, and the defendant had more rules. Jane had to kiss the defendant as soon as he came into the room. He did not want Jane to talk to friends or to have access to social media. She could not share personal information with the other girlfriends. He did not allow any of these young women to look at or be around other men. They had to turn away, leave the area, and tell the defendant immediately. They attended the defendant's nightly basketball games, but could only look at him. The defendant required Jane to report any rule breaking by the other young women, who in turn had to report Jane and one another. The defendant often made Jane write letters with false admissions for his protection. Sometimes he forced Jane to make videos as punishment. For example, he recorded her making false claim that her father molested her. Another time, the defendant forced her to smear feces on her face and to put it in her mouth and act like she liked it while she recorded it. The defendant spanked Jane nearly every 2 to 3 days, sometimes with such force he bruised her and tore her skin. On one occasion, the defendant confronted Jane about a conversation she had with a friend. The defendant accused her of lying and hit her all over her body, first with his hand and then with a shoe, until she finally broke. He regularly kept her in her room as punishment. For example, when Juice reported that Jane bought overly tight sweatpants, he also held her on his tour bus or the studio, sometimes for more than one day. The defendant also assaulted the other young women, which Jane saw. At times, the defendant compelled Jane to have sex with other women and men, the other girlfriends, his employees, and Alex, whom Jane knew as nephew. In these encounters, which he recorded, and the defendant orchestrated everything.
You want to go, grown men?
Okay.
Grown men, you there? Larry?
I'm here.
Okay, you want to take over, Faith?
Yes. Faith,
Okay.
count 1, Racketeering Acts 12, 13, 14, count 6, 7, 8, and 9. Faith met the defendant when she was 19 years old after March 2017 concert in San Antonio, Texas. 2 of the defendant's staff members invited Faith and her sister to an after party backstage. The defendant gave Faith a piece of paper with his telephone number on it and invited her and her sister to the dressing room. He asked Faith to text him her name with a picture of herself, which she did when she got home. After that, they communicated regularly. The defendant told her to call him daddy and hung up on her when she did not. The defendant told Faith that he loved her, invited her to see him on tour. He told her that Diana Copeland would arrange her travel and gave her Copeland's number. In May 2017, Faith traveled to New York and went to the defendant's concert. The defendant went to Faith's hotel room early the next morning and they had sexual intercourse, which the defendant recorded on his iPad. He did not wear a condom, nor did he tell Faith he had herpes. He also said that she could call him daddy if she was really like 16. Faith saw the defendant in Chicago 2017 in June and in Dallas December 2017. They engaged in sexual activity on both trips. The defendant told Faith that her legs should never be pointed to another man when she's in public with him. He said he had a group of women that he raised, but the defendant dismissed her concerns, telling her that it was his only sexual gratification that mattered. He also suggested that she sign some papers to protect him and to write something about her family, even if it was untrue. He directed Faith to send him a text message that said, "Daddy, I want to be with you and the girls." The defendant also told Faith that he had rules for his girlfriends, including a requirement that they greet him whenever he entered the room. When she went to Dallas, the defendant told Faith that they were going to a hookah bar. Faith, Joy, and the defendant got into the back of the Sprinter van while Donna Copeland got into the front passenger seat. When they arrived, the defendant and Copeland went inside the bar so that the defendant could see how many men were there, leaving Faith and Joy waiting for hours. Faith had to use the bathroom and tried to open the door, but Joy told her that the door was broken and she had to ask to leave. Faith texted Copeland that she was about to pass out. The defendant and Copeland finally returned and drove Faith to an IHOP to use the bathroom. Copeland followed her and Joy to the bathroom and stood outside the stall, but did not use the bathroom herself. They all returned to the hotel. Faith continued to communicate with the defendant after the Dallas trip. He wanted her to get permission to go out to tell him where she was going and who she saw. They should lock down, and Copeland asked to fuck up. In January 2018, the defendant paid for...
I believe she got immunity.
No, the only person got immunity was Demetrius. That's the only person. In January 2018, the defendant paid for and Copeland arranged Faith's travel to Los Angeles, California. When Faith arrived at the defendant's studios, Copeland told her to wait in the Sprinter, which was parked outside. After more than an hour, Faith texted Copeland that she needed to use the bathroom. Copeland escorted her to the restroom in the studio, then back to the Sprinter. Later, Copeland took Faith to a room in the studio. At one point, the defendant came into the room but left. Faith asked Copeland, could she go back to the hotel room or whatever. The defendant wanted her to wait. Copeland told her to wait. When the defendant showed up hours later, he told Faith that he would have come sooner if she had shown any excitement when he saw her earlier. The defendant directed her to take her clothes off and walk back and forth. Faith did not want to have sex with him, and she was on her period. The defendant sighed and said, "Well, why did you come?" He then told Faith to take off her pants and walk back and forth in her bodysuit. When the defendant took Faith to another room, she hesitated because she saw a gun on the ottoman. The defendant told her, "Don't look at it." His demeanor changed. He got real serious, sat in the chair, and told her to stand across from him. At this point, he had moved the gun by him. The defendant told Faith to pose while he took pictures with his iPad and was irritated because she was not being sexy enough. He started asking her questions. How many men have seen you naked? How many male friends do you have? Faith responded that none of her male friends had seen her naked. And the defendant said, "You want me to take that back? You want to take that back?" With a stern look on his face, the defendant claimed he would know if Faith was lying to him. The defendant then pulled a pillow on the floor and told Faith to get on her knees. He grabbed the back of her neck forward and instructed her to perform oral sex on him. Faith did not want to give the defendant oral sex, but was intimidated. The gun was now on the defendant's seat, and Faith felt that she could not leave because she was under his rules and he had a weapon. Faith traveled to see the defendant for the last time in New York in February 2018. He tried to have sexual intercourse with her, but she was clenching on purpose. The defendant got his iPad that he used to record them and masturbated while he watched a video of himself and other women having sex. Other evidence. The jury heard additional testimony and saw other evidence that corroborated the victim's testimony, including from the defendant's associate and employees. In addition to the government's introduced evidence from the defendant's storage facility, including an altered birth certificate for the woman that changed her birth date from 1993 to 1990, multiple false confession letters from the victims and employees, and recordings, including the audio recording in which the defendant, accompanied by George Kelly, accused Kyla, Jane Doe number 20, of stealing one of the defendant's watches. The defendant said, "You know how I am with cameras," and claimed to have cameras everywhere, including the studio, garage, and the van. Kyla admitted that That's Lisa. Kyla admitted that she took a watch, a t-shirt, earrings, and porno tapes, prompting the defendant to say the following: "There's only one way you're going to get rid of this, for me to trust your ass again. You're gonna do what the fuck I tell you to do. When you make the fucking tape for me and I looked at that shit, you was hiding your fucking face all over that shit because you didn't want to be seen. And you ain't gonna hide your fucking face on me. You're gonna do what the fuck I tell you to do, and you're gonna do it fucking right. Then I'm gonna gain my fucking trust back with your ass. And even if I detect you hiding on that shit, I'm gonna blow this shit the fuck up. Do you hear this shit I'm telling you? I fucking raised your ass. I raised you. You better not ever in your motherfucking life take from me again, or I will be in Florida and something else will happen to you. Defendant ordered Kyla to the garage and to stay there until he told her she could come out. He added, when I come and get you, you better be fucking like you're supposed to fucking be. You're not gonna go into tape until I tell you. When I tell you, I don't give a fuck if you're coming out of your sleep. You better be fucking ready. Do you understand? You make no fucking calls except to the studio or me. Defense case. The defense called 5 witnesses at trial. DeHoney Rummerman, an aspiring rapper who worked with the defendant for approximately 15 years. Larry Hood, the defendant's childhood friend and a former Chicago police officer, was on the defendant's security team. Jeffrey Meeks, who worked for the defendant more than 10 years, including as a runner. John Holder, the defendant's accountant from 2018 to 2019, and Julius Darrington, a music consultant who worked with the defendant for about 4 years. The defense witnesses testified that they never saw the defendant strike a woman, lock a woman in a room, or prevent a woman from eating or using the bathroom. Some of them testified that the defendant permitted them to be around his female guests and that the female guests were not required to look away or look at a wall. Hood, who regularly accompanied the defendant from the gym to White Castle to McDonald's to the studio, did not hand out the defendant's telephone number or recruit women for the defendant. He did not see the defendant with underage girls during his time as defendant's security guard. Meeks, who checked ID at the front desk of the defendant's studio, did not recall any woman being underage, although he was not sure if he inspected every ID. Thoroughly. Ramadan never saw the defendant verbally abuse women. Holder never saw the defendant abuse any of his girlfriends. Verdict. On September 27, 2021, the jury convicted the defendant of all counts. The jury found that the government had proved all the predicate acts except racketeering 3 and 4 relating to Sonia. Motion for acquittal. The defendant makes a Rule 29 challenge to the sufficiency of the evidence for every count of the indictment, the racketeering count, and each predicate act and all 8 man act counts. These challenges are unavailing. A court evaluated Rule 29 motion views the evidence in light of the most favorable to the prosecution and will uphold the jury's verdict if it determines any rational trier of fact that could have found some of the essential elements of the crime beyond a reasonable doubt. They cite case law. They cite more case law. To succeed, any Rule 29 motion must demonstrate that viewing the evidence in the light of the most favorable to the government. No rational trier would have found the essential elements of the crime charged beyond a reasonable doubt. Internal quotation marks and citation omitted. Viewing the evidence in the light most favorable to the prosecution mean drawing all inferences.
Wait, I lost you. Hold on, wait. There we go. I'm sorry. Sorry.
Okay. Inferences in the government favor and deferring to the government assessment of the witness credibility. They cite case law. Internal quotation marks and citation omitted. A court must consider the government's case in totality rather than in parts. And if the sufficiency test may be satisfied by circumstantial evidence alone, they cite more case law. Thus, a defendant challenging the sufficiency of the evidence bears a heavy burden. They cite more case law. Internal quotation marks and citation omitted. The defendant has not sustained his burden. That's what she said. The defendant has not sustained this burden. Do you want to read this? Or you want me to keep going?
Yeah, I'll go next.
Okay.
All right. Racketeering. The RICO statute makes it unlawful for any person employed by or associated with any enterprise whose activities affect interstate or foreign commerce to conduct or participate in the conduct of such enterprises' affairs through a pattern of racketeering activity. 18 U.S.C. 1962C. The statute further defines enterprise to include any group of individuals associated in fact, although not a legal entity. 18 United States Code 1961-4. As the Supreme Court has observed, the enumeration of included enterprises is obviously broad, and the term any ensures that the definition has a wide reach. They cite case law. An association, in fact, enterprise must have at least 3 structural features: a purpose, relationships among those associated with the enterprise, and longevity sufficient to permit these associates to pursue the enterprise purpose. An association, in fact, enterprise is a group of persons associated together for a common purpose of engaging in a course of conduct. An association, in fact, enterprise is simply a continuing unit that functions with a common purpose. The Supreme Court has consistently rejected arguments aimed at narrowing the statute's broad reach. Thus, see, this is the problem. That was the problem. That's why a lot of people were like, no, it's not a RICO because they weren't doing criminal activity. It has to do with illegal conduct. It doesn't matter what kind of activity. It's the fact that it's illegal activity. It doesn't have to do with drugs all the time. That's why they were having an issue with this whole thing of giving R. Kelly a racketeering charge, because of the way it's all about his sex life and this, that, and the third, and abuse. But there was sex trafficking involved from state to state to state. And he had this big organization which entailed all these people as moving parts working under his direction. So therefore, you have a RICO. Got it? Okay. An association, in fact, enterprise is simply a continuing unit that functions with a common purpose. The Supreme Court has consistently rejected arguments aimed at narrowing the statute's broad reach. Thus, an enterprise need not have a hierarchical structure or a chain of command. Decisions may be made on an ad hoc basis and by any number of methods: by majority vote, consensus, a show of strength, etc. Members of the group need not have fixed roles. The group need not have a name. Regular meetings, dues, established rules and regulations, disciplinary procedures, or induction or initiation ceremonies. While the group must function as a continuing unit and remain in existence long enough to pursue a course of conduct, nothing in RICO exempts an enterprise whose associates engage in spurts of activity punctuated by periods of quiescence. I don't even know how to pronounce that. Quiescence. Also makes clear that the RICO statute is not limited to groups whose crimes are sophisticated, diverse, complex, or unique. For example, a group that does nothing but engage in extortion through old-fashioned, unsophisticated, and brutal means may fall squarely within the statute's reach. So against this backdrop, I addressed the defendant's argument that the government did not establish the existence of an enterprise, that the enterprise activities affected interstate, like I just said, or foreign commerce, or a pattern of racketeering. Enterprise. In challenging the existence of the enterprise, the defendant does not appear to contest the evidence that he was at the top of an organization and that he had groups of employees and inner circle who worked to promote the defendant's music and brand and to tend to his personal needs. Relying on First Capital Assessment Management, Inc. versus case law, the defendant insists that the government did not prove a RICO enterprise. In Satinwood, the Second Circuit stated that for an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. Citing this language, the defendant contends that the government had to establish that the defendant, his employees, and entourage came together with one common purpose of recruiting women and girls to engage in illegal sexual activity and produce pornography, not merely the broader purpose of promoting defendant's music or brand. To the extent that Satinwood imposes a more stringent standard for pleading the existence of an enterprise, it conflicts with binding Second Circuit and Supreme Court precedent. As several district courts in this circuit have found, a bunch of case law, a judge explained that in Turkett, the Supreme Court distinguished the elements of enterprise and pattern of racketeering. The enterprise is an entity, for present purposes, a group of persons associated together for a common purpose in engaging in a course of conduct. The pattern of racketeering activity is, on the other hand, a series of criminal acts and defined by the statute. The former is provided by evidence of an ongoing organization, formal or informal, and by evidence that the various associates function as a continuing unit. The latter is proved by evidence of this requisite number of acts of racketeering committed by the participants in the enterprise. One element addresses group organization, while the other addresses conduct. The Supreme Court held that individuals in an enterprise must share a common purpose to engage in a course of conduct. The court did not say that the course of conduct must be fraudulent. Then it cites more of the case law. It says language conflicts with well-established precedent that RICO covers both legitimate and illegitimate enterprises. The United States Supreme Court has held that RICO protects the public from those who would unlawfully use an enterprise, whether legitimate or illegitimate, as a vehicle through which unlawful activity is committed. Internal citations omitted. Okay, case law. It is true that members of an association, in fact, enterprise, such as in now charged, must be connected by a common thread of purpose, and one might often expect such a purpose to be of a criminal nature. But the ultimate question is whether an association in fact exists. For this, it is not required that each participant have a separate mens rea, so long as each can reasonably be said to share in the common purpose. And the common purpose for R. Kelly was to promote his music and his brand and to lure girls for his own sexual gratification. And he was having illegal sex across state lines, traveling with the girls on the tour bus back and forth, having sex with them on there, the Sprinter. When he got to those states, in the concert venues, in the dressing rooms, come on. As Judge Coltell explained, if Satinwood required that a plaintiff allege a course of fraudulent or illegal conduct separate and distinct from the alleged predicate racketeering acts themselves, the decision would appear to conflict with the United States, and it cites a law in which the Court of Appeals held that proof of the separate elements of a RICO enterprise and a pattern of racketeering activity need not be distinct and independent, as long as the proof offered is sufficient to satisfy both elements. There also appears to be no doubt that these same statements are inconsistent with the holdings of Mazzi and its progeny. Okay. This court agrees with World Wrestling Entertainment on that point. The quoted portion portion of First Capital Statement is not well supported by Second Circuit precedent, as evidenced by the fact that First Capital cited only one district court opinion in support of it, and it is flatly inconsistent. And as the Honorable Kenneth, a whole bunch of law stuff in here, Karras explained, neither the Second Circuit nor the Supreme Court has expressly overruled Mazzei. This is critical because this court cannot ignore binding Second Circuit precedent unless it is expressly or implicated overruled. Okay. Finally, Judge noted that the validity of the enterprise pleading requirement was not in fact squarely before the Satin Wood Court, and that it was unclear why the Court of Appeals went on to discuss in dicta that adequacy of the complaint with respect to the RICO enterprise element when that issue was not raised on appeal and not briefed by parties. Accordingly, the government did not need to prove that every member of the enterprise shared a common criminal purpose. So determining whether the alleged members of the enterprise shared a common purpose, lawful or unlawful. Oh my God, they like repeated the same thing in like 3 different paragraphs. That shit is crazy. You know, it's because they're citing different laws, you know, different cases that happen with the same type of scenario. I also reject the defendant's claim. Okay, so she also rejects the defendant's claim that one of the enterprise's objectives, promoting the defendant's music, had no nexus to the underlying racketeering activity. And it cites the document 273-1 at paragraph 14. In this circuit, the nexus between RICO enterprise and the predicate racketeering acts may be established by evidence that the defendant was enabled to commit the predicate offenses solely by virtue of his position in the enterprise or involvement in or control over the affairs of the enterprise, or that the predicate offenses are related to the activities of that enterprise. And it cites another case law. The jury could rationally find both that the defendant was able to commit the predicate acts, predominantly illegal sexual activity with women and girls, because of his leadership position and control over the affairs of the enterprise, and that his underlying enabled his commission of the predicate acts. The jury could rationally find that Hardiman was able to sell drugs by virtue of his rank within the gang, and that his drug sales were related to the gang. So the government will try to prove that defendants' debt collection was successful because of their positions within the Gambino family. So they're showing all these examples. The Gambino organization. If so, such proof would satisfactorily connect the unlawful debt collection with the charged RICO enterprise. So the defendant's employees recruited young girls, women, including by locating them in the audiences of the defendant's concerts and inviting them backstage or to parties. So by passing them notes with the defendant's phone number and by trolling shopping malls and places like McDonald's and handing out the defendant's contact information. The defendant's employees arranged travel for his victims and enforced his rules. Now, you know, they're always saying that the girls were looking for R. Kelly. They sought him out. They sought him out. No, he sought them out. He sought them out. They were just in the shopping malls. They were hanging out at McDonald's. They were in the audience watching his concerts. He picked them out. He gave out his number. It wasn't the other way around. So can we get over that already? Thanks. So the defendant's employees recruited young women and girls, including trolling and shopping malls and places like McDonald's, and handing out the defendant's contact information. The defendant's employees arranged travel for his victims and enforced his rules. In turn, the defendant controlled his employees and ensured they implemented his rules. He punished them when they did not enforce the rules. For example, by withholding their pay. Testimony by Suzette Mayweather about the defendant fining her for having discussions with his girlfriends, or by requiring them to write letters falsely incriminating themselves. Testimony by Copeland about the defendant ordering her to write a letter falsely stating that she had stolen from him. The defendant also argues that the government failed to prove an enterprise distinct from the defendant because the members of the enterprise, the defendant's inner circle, associated together for no purpose other than to carry out defendant's needs. The case on which he relies, however, are distinguishable as they involve enterprises that consisted merely of a corporate defendant associated with its own employees or agents carrying on the regular affairs of the defendant. Cites more case law. As the Second Circuit explained, because a corporation can only function through its employees and agents, any act of the corporation can be viewed as an act of such an enterprise. And the enterprise is in reality no more than the defendant itself. Oh, one man is an enterprise. How about that? How about that? In the Second Circuit, the distinctness requirement bars a corporate entity from being named as both the defendant, person, and the enterprise on its own. The defendant is not a corporate entity. An individual defendant who acts through a corporation. The defendant is not a corporate entity. An individual defendant who acts through a corporation may have formed an association, in fact, with an entity distinct from himself. Then it says some case law. Okay, so who allegedly conducted the corporation affairs in a RICO forbidden way that a corporate owner / employee, a natural person, is distinct from the corporation itself. Internal citation and quotation marks omitted. RICO case is one in which a person bent on criminal activity seizes control of a previously legitimate firm and uses the firm's resources, contacts, facilities, and appearance of legitimacy to perpetrate more and less easily discovered criminal acts than he could do in his own person. So the defendant is clearly distinct from his enterprise, which included the defendant and a group of other people. So the fact that the group associated to support the defendant and meet his needs does not make it indistinguishable from the defendant. So as the Supreme Court has held, there is nothing in the statute that requires more separateness than that.
Okay. So one man is an enterprise.
Okay, one man is an enterprise. How about that? You wanna go in, brother? I need a break.
I'm going. All right, let's go. Interstate Commerce. The defendant also disputes the interstate commerce aspect of the government's case. To satisfy the RICO statute's interstate commerce element, the government must prove that enterprise engaged in interstate or foreign commerce or that its activities affected interstate commerce, or foreign commerce, 18 U.S.C. 1962. However, only in a minimal effect on interstate commerce need be proven. They cite case law. Conduct having a de minimis effect on interstate commerce suffices. They cite more case law. Transporting goods across state lines is the classic example of engaging in interstate commerce. Use of an instrumentality of commerce, such as a telephone line, is also generally viewed as an activity that affects interstate commerce. At trial, the government established that members of the enterprise arranged travel across state lines and internationally for the defendant, other members of the enterprise, and the defendant victims. As explained in more detail below, multiple predicate acts allege that the enterprise members arranged the interstate transportation of the defendant's victims in violation of the Mann Act. That evidence, which jury credited, is sufficient to establish an effect on interstate commerce. They cite more case law. Finding that in the context of Hobbs Act violations, which only requires a minimal effect of interstate commerce to support a conviction, the defendant's travel across state lines as part of a robbery scheme clearly demonstrates an effect on interstate commerce. The government also presented evidence that the defendant used phones and instrumentality of interstate commerce to communicate with victims located in different states, and that the enterprise members communicated by phone with the defendant's victims.
This has to do with Geronda.
Yeah, that too is sufficient to establish an interstate and an effect on interstate commerce. They cite more case law. Finding effect on interstate commerce based upon the use of the interstate phone system to get approval for credit card transactions. Pattern of racketeering. A pattern of racketeering activity requires at least two acts of the racketeering activity of which occurred after the effective date of the statute and the last of which occurred within 10 years, excluding any period of imprisonment. After the commission of a prior act of racketeering activity, the government must show that the racketeering predicates are related and that they amount to or pose a threat of continued criminal activity. These requirements protect defendants from RICO charges based upon isolated or sporadic criminal acts. Predicate acts must be related to each other and to the enterprise. They cite more case law. The racketeering acts must be related to each other, horizontal relatedness, and they must be related to the enterprise, vertical relatedness. Continuity is both a closed and open-ended concept, referring either to a closed period of repeated conduct or to past conduct that by its nature projects into the future of a threat of repetition. The defendant disputes evidence on every predicate act and the evidence of relatedness and continuity as to some acts. Bribery. Racketeering Act 1 charged the defendant with bribing a public official with the intent to influence the creation of a fraudulent identification for Aaliyah. The defendant argues that the evidence did not prove that he caused Demetrius Smith to pay for a public employee to secure identification for Aaliyah. Specifically, the defendant contends that the record does not show he knew of or facilitated the bribery. He cites portion of Smith's testimony, including Smith's testimony that Darren McDavid gave him the cash to pay for the bribes and that he was not passive whether he discussed the bribery with the defendant. The evidence viewed as a whole sufficiently tied the defendant to the bribery. You hear that? Do you hear that? The evidence viewed as a whole sufficiently tied the defendant.
Read that again, bro. Yes, read that again.
So it says the defendant argues the evidence did not prove he caused. Defendant argues that the evidence, he basically saying that R. Kelly lawyers arguing that the evidence did not prove that Demetrius Smith to pay for a public employee identification for Aaliyah. Specifically, the defendant contends that the record does not show that he knew of a facilitated bribery.
He knew about it. Right.
He cites portion of Smith's testimony, includes Smith's testimony that Darren McDavid gave him the cash to pay the bribes, and that he was not positive whether he discussed the bribery with the defendant. The evidence viewed as a whole sufficiently tied the defendant to the bribery. Indeed, there were ample evidence from which a rational jury could conclude that the defendant knew of and facilitated the bribery. After all, the defendant was the only person who stood to gain from the bribery. He feared that Aaliyah then was only 15 years old, was pregnant, which would have revealed the defendant's sexual relationship with her, as he told Smith he needed to marry Aaliyah to protect himself. Smith, the defendant, and McDavid discussed how to make the marriage happen. especially if Aaliyah was too young to be married without parental and judicial approval at the time. Smith suggested that he could obtain fraudulent identification to enable the defendant to marry Aaliyah. The defendant was part of the group that drove to the welfare office and a FedEx office to get Aaliyah fraudulent identification. Using those documents, the defendant and Aaliyah applied for and received marriage license at the Maywood City Hall. An official recommended by the defendant's friend conducted the hasty ceremony that took place in a hotel. The jury was entitled to infer from this evidence, including from the defendant's obvious interest in protecting himself, that he knowingly participated in or facilitated the bribery. They cite case law. A defendant knowing and willing participation in a conspiracy may be inferred by his presence at a critical stages of the conspiracy that could be explained by happenstance. May also be established by evidence that the defendant participated in conversations directly related to the substance of the conspiracy. So basically, what they're saying is that you don't gotta say shit. You roll to the motherfucking Kinko's.
That's it.
You roll to the courthouse. You roll to where they got the ID from. You the only one that stand the game from the bribery. Nigga, this shit was for you. And you the only motherfucker that got her pregnant, and you the only motherfucker that need to get married. So
hello.
Boom.
So at the end of the day, he's guilty.
Yeah. The jury was entitled to infer from this evidence, including the defendant's obvious interest in protecting himself.
Wait, where were we?
I skipped that. To be sure, Smith recalcitrant and combative, sometimes hedged about the extent of the defendant's role in the bribery. I actually didn't have any discussion with Robert. It was Daryl. I'm not sure if Robert was there. At times, he confirmed that the defendant was present during the bribery conversation. I don't remember precisely each time, but I'm pretty sure the defendant was there. I'm pretty sure the defendant was there with me, so I guess I could say yes.
He sounded mad crazy in the trial. Like what? It was like he was hesitating to tell the truth.
Right. That's crazy.
He was scared. I think for some reason when that happened, something within me personally said, I think he was threatened by R. Kelly's goons or something.
Niggas ain't no goons.
Who knows?
In deciding the Rule 29 motion where there are conflicts in the testimony, the court must defer to the jury's resolution of the weight of the evidence and the credibility of the witnesses. A jury is entitled to believe in part and disbelieve part of the testimony of any given witness. Smith was explicit that he did not want to testify. Yes, I do not want to be here, period. And that he was uncomfortable testifying about the defendant's age to Aaliyah. I'm uncomfortable with this, Your Honor. I'm truly uncomfortable. We're continuously talking about Aaliyah. Her parents are not here, and I don't understand why I got to do that. Moreover, he was reluctant to incriminate the defendant, having known him since 1984, just like a brother. A rational jury could credit the portions of Smith's testimony confirming the defendant's participation in the bribery and reject his conflicting testimony.
Okay.
The defendant's further argument that the predicate act of bribery lacks vertical and horizontal relatedness is also unpersuasive. As explained below, vertical relatedness may be established by evidence that the defendant was unable to commit the predicate offenses solely by virtue in his position of the enterprise or involvement in or control over the affairs of the enterprise, or that the predicate offenses are related to the activities of the enterprise. Emphasis and internal quotation marks are omitted. In this case, the defendant was unable to commit bribery because of his position as the head of the enterprise.
He was able.
Yeah, he was able to commit bribery because of his position as the head of the enterprise and his ability to direct members of the enterprise to do his bidding. Furthermore, the jury could reasonably find that the bribery was necessary to further the enterprise. The marriage to Aaliyah protected the defendant, his image and his career by shielding him from the consequence of having sex with a minor, prison, shame, and disgrace. The evidence also established horizontal relatedness. The defendant and his associates committed bribery as part of an in order to facilitate the defendant's sexual activity with women, young girls, including illegal sexual activity. Predicate acts are horizontally related when they have the same or similar person, results, participants, victims, or methods of commission, or otherwise are interrelated by extinguishing characteristics that are not isolated events. production of sexual explicit material.
Wow.
Woo.
Yeah.
I'm gonna read this.
Go ahead, baby.
No. Okay, well, here we go. Racketeering Act 2. Stephanie Geronda, number 10, Jane, charged the defendant of sexual exploitation of a child. The government was required to prove that the victim was less than 18 years old. The defendant used, employed, persuaded, induced, enticed, or coerced a minor to take part in sexually explicit conduct for the purpose of producing a visual depiction of that conduct. The visual depiction was produced using materials that had been transported in interstate and foreign commerce. She cites case law. The defendant does not deny the evidence that he taped his sexual encounters with these 3 victims, nor does he dispute that they were minors at the time that he taped them, instead claiming that the government had to prove that the defendant did something more than just film the sexual explicit conduct. He contends that the government did not prove that he did anything to persuade, induce, entice, or coerce Stephanie, Geronda, or Jane into sexual activity that was recorded. The defendant misstates the applicable law and facts established at trial. A defendant can't be found to have used a minor to produce child pornography if the minor serves as the subject of the illicit photographs taken by the defendant, citing case law, agreeing with the Second Circuit also. As the defendant concedes, several circuits, including the Second Circuit, has held that the use of elements set forth in 2251 is satisfied when a defendant intentionally films a minor sexually explicit conduct. Nevertheless, the defendant argues that the Second Circuit interpretation would render the remaining terms in the statute persuade, induce, entice, or coerce superfluous.
What?
But
No, you said that right, puppy. I'm just saying, like they just threw that word out of nowhere.
Right, but district courts are bound to follow controlling second court precedent unless the precedent is overruled or reversed. And they cite more case law. Thus, this court is bound by the Second Circuit holding in Sorois. In any event, the defendant's challenge is meritless. Section 2251 requires proof of active or coercive conduct by a defendant upon the minor. The broad interpretation of the use applies when a defendant engaged in active conduct. For example, if the defendant photographs or films a minor or directs the photography or filming of a minor, class.
Like you sit here, you stand there, you bend over, exactly what he does.
Right. Finding that the use element was satisfied when the photographs were taken by the defendant. Finding that the use element was satisfied when the defendant directed the minor's actions. A defendant may engage in coercive conduct and produce, induce, entice, or coerce a minor to produce child pornography, for example, by persuading a minor to take pornographic photographs of herself or himself. They cite more case law, finding that the government had not induced sufficient evidence that certain pornographic photos taken by a minor were taken at the defendant's behest. According to the words persuade, induce, entice, or coerce, Section 2251 are not rendered meaningless by the Second Circuit interpretation of use.
Wow. So it doesn't matter. He was directing. He could have been just watching. You were involved, my man.
Right. In any case, the defense argument is foreclosed by evidence showing that the defendant engaged in persuasive, coercive conduct with Stephanie, Geronda, and Jane. They testified, as did other witnesses, about the punishment that the defendant exacted when they broke his rules, and the physical and emotional manipulation they endured to meet the defendant's sexual demands. Based on this testimony, a reasonable jury could find that the defendant similarly persuaded or coerced the victims to engage in the sexual explicit conduct. The defendant also argues that the government did not prove that he acted with a purpose of producing a visual depiction, and the jury charge on this element was wrong. An examination of the charge itself, to which the defendant did not object, refutes that claim. The court explained that Racketeering Acts 2, 7, and 10 charged the defendant with using a minor to engage in sexually explicit conduct for the purpose of producing one or more visual depiction of such conduct. Then the court quoted the relevant portion of 18 U.S.C., which provides, a person who employs, uses, persuades, induces, entices, or coerces any minor to engage in any sexually explicit conduct for the purpose of producing any visual depiction of that conduct shall be punished. If a person knows or has a reason to know that the visual depiction will be transported in interstate or foreign commerce or mail, if that Visual depiction was produced using materials that had been mailed, shipped, or transported in interstate or foreign commerce by any means including a computer, or if the visual depiction had been transported in interstate or foreign commerce or mail. Finally, the court discussed the elements that the government had to prove. To prove that the defendant committed this racketeering act, the government must prove that the following three elements were met by a reasonable doubt. First, that Stephanie was under the age of 18 at the time the acts was alleged in the indictment. Second, that the defendant used, employed, persuaded, induced, or enticed Stephanie to take part in sexually explicit conduct for the purpose of producing or transmitting a visual depiction of that conduct. Third, that the visual depiction was produced using materials that had been mailed, shipped, or transported in and affecting interstate and foreign commerce. While the government must prove that the defendant acted with the purpose of producing sexually explicit visual depiction, the government does not need to prove that a visual depiction of sexually explicit conduct was actually produced.
Okay, wepa. There you go.
The court's charge viewed in its entirety made it clear that the jurors had to determine whether the defendant's purpose was to produce a visual depiction. Accordingly, the jury instructions taken at whole and in light of the evidence show no tendency to confuse or mislead the jury as to principles of the law which are applicable. Finally, the defendant maintains that the government proved to fail that the interstate commerce element, that the visual depiction were produced using materials that have been mailed, shipped, or transported in interstate or foreign commerce for racketeering to Acts 2 and 7. This claim is also unpersuasive. Stephanie testified that the defendant filmed her in Illinois using a video camera on a VHS tape. The defendant acknowledges that the parties stipulated that the type of film used in VHS tapes was not produced in Illinois during the relevant time period. So hold on. It don't matter if he made the tape in Illinois. They're saying that the fucking material used to make the tape was not produced in Illinois during the relevant time period. Right. That is sufficient to satisfy interstate commerce element. That's crazy. It does not matter.
That evidence is submitted.
Exactly. It don't matter if he fucking filmed her in fucking Illinois. The shit that they made the videotape with was not.
Right. Exactly.
Wow, that is sufficient to satisfy the interstate commerce.
That's why that was proven with Geronda Pace.
Right. They cite case law. Geronda testified that the defendant made a recording of her in Illinois using an iPhone and a Canon camera. Despite this testimony, the defendant claims that the government did not establish what device, if any, was used to make these recordings, and therefore its affecting interstate commerce evidence was insufficient. However, the jury was entitled to credit Geronda's testimony about the devices and the defendants used, and the government's evidence that both devices were produced out of state.
Exactly what you said, Grum Boy.
Accordingly, there was sufficient evidence to convict the defendant of racketeering Acts 2, 7, and 10. Exposure to a sexually transmitted disease intent, racketeering Acts 8, Jane 12A, Faith 12A, 14A. Charged the defendant with transporting a person in interstate commerce with the intent to engage in sexual activity exposed to this person to herpes, which violates certain criminal and public health statutes. C 18 USC 2421. Whoever knowingly transport any individual in interstate or foreign commerce with the intent that such individual engage in any sexual activity for which any person can be charged with a criminal offense or attempts to do so shall be punished.
Boom.
And this claim that the government did not prove that he transported Faith or Jane with the intent of exposing her to herpes. Once again, the court charged the jury of the element of intent, a charge to which the defendant did not object.
Oh.
In order to establish this element, it is not necessary that the government prove that engaging in illegal sexual activity was the only purpose for crossing the state line. A person may have several different purposes or motives for travel, and each may prompt in varying degrees the act of making the journey. The government must prove beyond a reasonable doubt, however, that a significant of motivating purpose of the travel across state line was that the defendant would engage in illegal sexual activity with the victim. In other words, that illegal activity can't have been merely incidental to the trip. The defendant maintains that illegal sexual activity must be the dominant purpose of the travel as opposed merely a significant or motivating purpose. That is not the standard in the circuit. The word dominant does not appear in the statutory language. Courts in the circuit have adopted the significant or motivating purpose standard. She cites case law. Cites a lot of case law. Cites more case law. Using significant or motivating purpose stand a jury for violation of 18 U.S.C. transportation of a minor with intent to engage in legal sexual activity. Cites more case law. The defendant does not challenge that the evidence at trial demonstrated he contracted genital herpes between 2000 and 2007, that his doctor, Chris McGrath, informed him of the diagnosis, and Dr. McGrath told him to use a condom during sexual intercourse to let his partners know of his diagnosis. Nor does he appear to challenge the evidence showed that he never used a condom during sex with Jane and Faith, and that he never told Jane and Faith that he had diagnosed with herpes. Rather, the defendant argues that there is no evidence that the defendant's action of arranging for Jane and Faith to travel to meet him was motivated by an intent to expose them, rather than to simply have sex with them. Wow, because the defendant purported violation of New York public health law prohibiting from having sex with minor was indicted to Faith's trip rather than a motivating purpose in transporting Faith, the intent requirement of the statute cannot be sustained. The plain language of 18 U.S.C. 2421 requires that the defendant transported Jane and Faith with the intent that they engage in sexual activity for which any person can be charged with a criminal offense. Thus, after the court instructed the government was required to prove that the defendant transported Jane and Faith with the intent of engaging in sexual activity with them, and that the intended sexual activity was illegal. The record established that the defendant appears to concede that his motivation in arranging for Jane and Faith to travel to meet him was to engage in sexual activity with him. In light of Jane and Faith's testimony, as well as other witness testimony about their sexual experience with the defendant, the jury could reasonably conclude that the defendant intended to have sex with them without a condom and without informing them that he had herpes. And as explained in section I-5 below, the defendant could be charged with criminal offenses for their sexual activity because he exposed Jane and Faith to genital herpes, which violated state and criminal and public health statutes in existence. Accordingly, the evidence was sufficient to prove the intent element. Exposure to a sexually transmitted disease persuading.
Sorry, I'm lost, little boy. I had some activity going on in the background.
52. At the bottom of 52. Exposure to a sexually transmitted disease, persuasion, inducement, enticement, or coercion. Racketeering's 8B, Jane, Faith, and Faith charged the defendant with persuading, inducing, enticing, and coercion to travel interstate commerce to engage in sexual activity that exposed the person to herpes, which violated certain state and criminal public statutes. Whoever knowingly persuades, induces, entices, or coerces an individual traveling in interstate or foreign commerce to engage in any sexual activity for which persons can be charged with a criminal offense or attempts to do so shall be punished. The defendant asserts that there is no evidence that he took any action to induce, persuade, entice, or coerce Jane into traveling to California in April or May 2015. Instead, he says, citing text messages between Jane and her mother, the record shows that Jane's mother purposely and strategically enticed the defendant with her 17-year-old daughter. According to the defendant, he merely invited Jane to join him, and she excitedly accepted. In his challenge to the evidence about Faith, he maintains that he invited a grown woman to meet him in New York, and she accepted. The words persuade, induce, entice, or coerce, though not defined in the statute, are words of common usage that have plain and ordinary meanings. Cites case law. Section 2242 imposes no requirement that an individual endeavor to transform or overcome the will of his intended victim. In fact, the jury need only consider that the defendant intended to induce, persuade, or entice the victim to travel to engage in sexual activity with him, regardless of whether she expressed or felt reluctance, indifference, or for that matter, enthusiasm at the prospect of doing so. He cites case law. The jury was entitled to conclude from the evidence that the government proved the elements of these charges. As Jane testified, the defendant made it clear from their first meeting when she was a junior in high school that his interest in her was sexual. Thus, he persuaded her to engage in sexual activity with him, telling her that he needed to ejaculate before he could audition for him. He also told Jane that he wanted to see her again and teach her a few techniques. He proposed that she meet him in Los Angeles, California, and gave her number to assistant Cheryl Mack so that Mack could make the travel arrangements for which he paid. Similarly, it was clear that the defendant was interested in having sex with Faith when she met him in San Antonio, Texas concert in March 2017. After the defendant gave Faith his contact information, they communicated regularly. The defendant told Faith that he loved her and invited her to meet him when he was on tour so they could hang out, which would be fun. As he did with Jane, the defendant gave Faith Diana Copeland's telephone number. Faith contacted Copeland, who arranged for her to travel to New York in May 2017. The defendant paid for the flight. Copeland also booked the defendant's trip and paid for her to travel to New York in February 2018. A reasonable jury could find that the defendant did far more than simply invite Jane and Faith to meet him, and that he persuaded, induced, and enticed Jane to travel by offering incentives, suggesting that he would teach her singing techniques, and by offering to make and pay for the necessary traveling arrangement. The jury could also rationally find that the defendant persuaded, induced, and enticed Faith to travel May 2017 by telling her that he loved her, by assuring her that her trip would be fun, and by arranging and paying for all of her travel. The fact that Faith and Jane may have been willing or even eager to travel is not relevant. Holding that the defendant intent that forms basis for his criminal liability, not for the victims. Holding that it is not significant that the victims had pre-existing wishes to travel when they never acted upon those desires until the defendant made it attainable. Exposure to a sexually transmitted disease, criminal and public health statutes, as discussed above, Racketeering 8, Racketeering 12.
You want me to read the next one?
Yeah.
Okay.
Charged the defendant with manic violations based on a violation of criminal and public health statutes, specifically New York penal law. They cite that penal law. They cite California penal law. The defendant argues that the evidence at trial was insufficient to establish a violation of NYPL. And then they said NYPL 2307 is unconstitutionally vague. He also asserts that the government improperly charged him with an older version of CHSC, in any event that the evidence did not establish a violation of CHSC. I address these arguments in turn. NYPL provides a person is guilty of reckless endangerment in the second degree when he engages in a conduct which creates a substantial risk of a serious physical injury to another person. Serious physical injury, a physical injury that creates a substantial risk of death, or which causes death and serious and protracted disfigurement. Proactive impairment of health or protracted loss and or impairment of the function of any bodily organ. The defendant argues that an unprotected sex with someone who has genital herpes does not establish a substantial risk of serious physical injury because herpes is not deadly and rarely cause any serious and protracted health impairments. He also claims that there is no evidence that he was contagious or had an outbreak, which when he was in New York. The defendant claims that herpes is not deadly and rarely causes any serious protracted health impairments. As an initial matter, ignore the entirety of the statutory definition, which includes not only causing death or creating a substantial risk of death, but also causing serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of a function of bodily organ. A rational jury could find from the trial of evidence, except expert and otherwise, that the defendant exposure of victims to an incurable disease met these definitions. She names doctors, explain that herpes is incurable and very contagious, transmittable virus. Once the virus enters the central nervous system, it's going to stay there. And it's always there. So it can reactivate. And when it reactivates, it can cause a result or an effect. Other parts of the body. Herpes manifests as blisters, ulcers, and some other shit, causing burning, tingling, numbness, severe pain. Outbreaks can be triggered by various factors: menstruation, a common cold, a cough, sunlight, and other illness such as asthma, cancer, hypertension, and diabetes, and can last anywhere from several days to weeks. Herpes can cause other medical complications, including to the central nervous system, the brain, or the bloodstream. While these complications are rare, they always remain a risk for someone with herpes. The jury could reasonably find, based on Dr. Hopkins' expert testimony, that the transmission of genital herpes, a permanent and incurable disease that causes recurrent outbreaks with potential life-threatening complications, constitutes a serious physical injury. They cite more case law. Moreover, the defendant's victim testified about the intensity of their physical symptoms, as well as the psychological effects of being saddled with the incurable sexual transmitted disease. As for the defendant's suggestions that he might not have been symptomatic, Dr. Hopkins explained that someone with herpes can transmit the virus even if he's asymptomatic, because the virus can be excreted at a time when there is no evidence that it can be reactivated. While taking medications like Valtrex, which the defendant took, can reduce the risk of transmission, there will never be a situation where there's a 100% protection. There will still be a 10 to 20% possibility of transmitting the virus, and a missed dose or a missed window of time can add to that percentage. Similarly, the defendant's doctor, Chris McGrath, not only described the symptom of herpes, but also advised the defendant to use a condom during sex, prompting the defendant himself acknowledgement that he should have used a condom when having sex. Dr. McGrath also told the defendant to warn his partners that he had herpes and repeatedly prescribed Valtrex for the defendant. Moreover, Kate and Jane contracted herpes from the defendant early 2015. Given this evidence, a rational jury could find that there was a substantial risk of transmission that the defendant consciously ignored. NYPHL provides that any person knowing himself to be infected with an infection of venereal disease has sexual intercourse with another shall be found guilty of a misdemeanor. The defendant repeats the arguments he made before trial in seeking dismissal of these counts, that the statute is unconstitutionally vague. In addition, he claims that the statute does not define the term infected. The defendant concedes that his constitutional claims regarding NYPHL are not challenged to the sufficiency of the evidence and thus not properly the subject of Rule 29 motions. Only authorized motions challenging the sufficiency of the evidence presented at trial. She cites again the case law, noting that the defendant's challenge to charge in the indictment was not properly raised on a motion for judgment of acquittal pursuant to Rule 29. The defendant argues that the government did not prove that he violated CHSC because the government charged the defendant with a repealed version of the statute no longer in effect and proposed jury instructions that rewrote the statute in clear violation of various constitutional provisions. He also categorized the statement as impermissibly vague and claims there was insufficient evidence to prove the charge in any event. Each of the defendant arguments is unavailing.
You want me to read?
Go ahead.
The 1998 version of CHSC 12290 was in effect at the time of the charge conduct in April and May of 2015. That version of the statute, which remained effective through 2017, provided, except as provided in Section 12291, or in the case of the removal of an afflicted person in a manner that the least dangerous to the public health, any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and any person who willfully exposes another person afflicted with the disease to someone else, is guilty of a misdemeanor. All right. The current version of Section 12290, which did not take effect until January 1st, 2018, makes it unlawful for someone to transmit an infectious or communicable disease, provided that he knows that he is afflicted with an infectious or communicable disease, acts with the specific intent to transmit that disease to another person, engages in conduct that possesses a substantial risk of transmission to that person, and transmits the infectious or communicable disease to the other person. Thus, while the 1998 version required, among other things, that a defendant act willfully in exposing himself to another person, the 2018 version requires that a defendant act with a specific intent to transmit the disease. The indictment made it clear that the 1998 version of 12290 formed the basis for the Mann Act violation charged in Racketeering Act 8A and 8B. The defendant, together with others, did knowingly and intentionally transport an individual, to wit, Jane, in interstate commerce with intent that such individual engage in sexual activity for which a person can be charged with a criminal offense, to wit, violations of California Health and Safety Codes 120-290, effective 1998. Willful exposure of communicable disease, in that the defendant engaged in unprotected sex intercourse with Jane without first informing her that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. Similarly, when the court instructed the jury regarding CHSC 12290, it quoted the 1998 version of the 12290 and set forth the elements that the government was required to prove in order to establish in violation under that version. In this Racketeering Act, the illegal sexual activity that is charged is a violation of California law, specifically California Health and Safety Code section 12290. And under the law, any person who is afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person shall be punished. This is what the government must prove beyond a reasonable doubt. First, that the defendant knew that he was afflicted with any contagious and infectious and communicable disease. Second, the defendant exposed himself to Jane by engaging in unprotected sexual activity with her. Third, the defendant acted willfully. And fourth, that the defendant did not inform Jane that he had a contagious, infectious, or communicable disease and obtain her consent to expose himself in these circumstances prior to engaging in the exposure. A communicable disease is any disease that was transferable through the exposure incident. With respect to the third element, I have already defined this for you. I think that's willfully. That means with knowledge of the consequences or purposefully. It does not require that the defendant intended to expose another person to a contagious or infectious or communicable disease. The court then instructed the jury about these same elements for the Mann Act coercion and enticement offense charged in Racketeering Act 8B. Federal Rule of Criminal Procedure 12 requires that certain objections to a prosecution or indictment must be raised by pre-trial motion if the basis for the motion is then reasonably available, and the motion can be determined without a trial on the merits. Federal Rule Criminal P 12B3, the requirement serves a number of purposes, including sparing the court, the witnesses, and the parties the burden and expense of a trial, and ensuring that indictments are not routinely challenged and dismissed after the jury has been seated and sworn. While a motion that the court lacks jurisdiction may be made at any time while the case is pending, a motion that asserts a defect in instituting the prosecution or a defect in the indictment must be made before trial if the basis for the motion is then reasonably available, and 2, the motion can be determined without a trial on the merits. And then it says case law, and it says that Rule 12B3 includes a list of commonly raised claims under each category, including failure to state an offense and lack of specificity. I can't even say that right. In an indictment, among others. Then it says Federal Rule Criminal Procedure 12B, 3B3, and V. Now, if a defendant does not make a motion that falls within Rule 12B3 before trial or by the deadline set for the court for such motions, the motion is untimely and is deemed waived absent a showing of good cause. So if the motion is untimely, the court may nonetheless entertain it if the movant shows good cause for his failure to make it prior to the deadline. Now, the defendant's claims about the California statute should have been made in Rule 12 motion, because he is claiming that there were defects in the indictment. So, rejecting defendant's post-trial constitutional challenge to indictment charging unlawful conduct with respect to methylone because the claim asserted a defect in the prosecution's institution or a failure to state an offense. Finding the defendant's post-trial challenge to an indictment charging attempted aggravated identity theft was a claim that the indictment was defective for failure to state an offense, not jurisdictional, and therefore waived. So in other words, they put in, when Bonjean came in and decided to talk about that in the motion for acquittal or new trial, I forgot which one it was. It doesn't matter because she should have done that. His team should have done that before trial started. So, and that's according to the Rule 12. Let's go a little bit. I'm going to try to go a little bit further. All right. So, the defendant has not adequately explained his failure to raise his current arguments about the 12290 earlier. So, his only justification is that the government did not apprise the defense of its intent to have the jury charged pursuant to a repealed version of the statute that it also rewrote. So, but the information supporting the defendant's challenge to 12290 was reasonably available to him as early as March 12th of 2020, when the superseding indictment was returned against him, making clear that the government charged the 1998 version of the 12290 rather than the 218 version. On July 2nd, 2021, little more than a month before the trial, the government submitted proposed jury instructions, which also alerted the defendant that the charge was based on the 1998 version of the statute. Now, the information the defendant cites for his vagueness argument was also available to him before trial. So, indictment currently at issue is the same document defendant reviewed before trial. So, if the document is vague now, then it was vague then, which is when defendant should have voiced his concerns. So, in fact, the defendant raised vagueness about the NYPHL 2307 in his pretrial motion to dismiss and to strike. He could have made similar challenges to CHSC 12290, which he did not. So the defendant has not established good cause for his failure to challenge the CHSC 12290 in Rule 12 motion. So accordingly, not only are the defendant's constitutional claims about the 12290 beyond the scope of a Rule 29 motion, in any event, the defendant's argument are without merit. He challenges the 1998 version of the statute on as applied and facial grounds. I guess those would be factual grounds, arguing that it fails to provide adequate definitions that put individuals with any chronic and potentially contagious disease on notice of what amounts to criminal conduct, including communicable diseases that are not sexually transmitted. Now, it has an emphasis on in the original. He theorizes that anyone with herpes simplex 1, also known as cold sores, who kisses another person without disclosing that they have herpes simplex 1 is guilty of a misdemeanor. The defendant is foreclosed from challenging CH 12290 for vagueness, either on an as applied or on a factual basis, on a facial basis. The due process clause of the 14th Amendment requires that every criminal statute, 1, give the person of ordinary intelligence a reasonable opportunity to know what is prohibited, and 2, provide explicit standards for those who apply the statute. Okay, decide more case law. So due process, if it fails to give ordinary people fair notice or is so standardless that it invites arbitrary enforcement, even if there is ambiguity as to the margins of what conduct is prohibited under the statute. Dickerson, it is clear to an ordinary person that the 12290 would prohibit the defendant's conduct having unprotected sex, knowing he had herpes, and without informing his partner. Moreover, as applied vagueness challenge supported by a law's potential for arbitrary enforcement must fail if the enforcement at issue is consistent with the core concerns underlying the statute. The defendant's conduct falls within the 120 clear core protecting the public from the spread of infectious venereal disease. Okay, accordingly, the defendant cannot show that the statute is vague as applied to him, nor is factual challenge available to the defendant. I'm starting to get tired, guys. Outside of the First Amendment context. Challenges are permitted only when no set circumstances exist under which the law would be valid. All right. Or where the law infringes upon another constitutional protected right. Okay.
You want me to take it up?
Yeah, go ahead, because it's 103 pages, Larry.
You want to do part 2 tomorrow?
Yeah, I think we should. After the trial, we can start. Are you working tomorrow?
You gotta be down there tomorrow. I gotta work tomorrow. But
what time you get off?
Try to be out of there about 2:30, 3 o'clock. Y'all will be back at home before then. But
so 3 o'clock your time, you're saying?
Yep.
You'll get home 3 o'clock your time. So that'll be 6 o'clock for me.
Okay.
All right. So I guess maybe we'll come back on at about 7 p.m.
That'll work.
Sounds good. Well, 7 p.m. for me, 4 p.m. for you.
All right.
All right. So, guys, we're going to call it a wrap. We're going to leave it right here at page 65. All right.
All right.
So, Larry, thank you so much, my love. Thank you, brother. Thank you for helping me out. Guys, thank you so much for hanging out with us so late. I got to at least try to get 4 hours of sleep, guys. So I could roll out of here. So, guys, I will definitely see y'all in the morning. Okay. Please make sure you guys go subscribe to the Grown Little Boy channel. Guys, if you can, please put in the chat Grown Man's channel, please. Por favor. Thank you. Thank you. Okay. All right, guys. So you guys will be hearing from me in the morning. You're very welcome, guys. And it's doomsday, y'all. It's doomsday. We got a few hours left. Tick, tick, ticking. Guys, please do me a favor. Don't forget to hit that like button before you leave. Thank you very much, guys. And for those who are watching the replay, please leave your comments in the comment section below. And you already know, Diva Divine Light is out. Peace.